All right, let's take you back now to one of our leading stories and get an update from the High Court in Pretoria. And that's where the Senzo Meyiwa murder trial has adjourned until 2 p.m. That is this afternoon. Newzroom Afrika's Mnisi joins me live now. Linda, good morning to you. Watching the proceedings a little earlier, you could tell that this was going to be a long delay today to the start of this trial. Let's get into why that is. There is a particular document that the lawyers have to read through. Talk to us about what that docket is about.
In fact, it's about 4 dockets that, are currently in dispute or at the center of why the case had to be adjourned till 2 p.m. this afternoon. You'll remember yesterday the defense was, asking questions during cross-examination around the lawfulness of the arrest of accused 1 and 2. And if you go back to the testimony that we previously heard in court, is that they were arrested on separate matters first and stayed in prison for about 5 months before they were charged for the murder of Senzo Meyiwa. Now, in question now is the dockets that they were involved in and the investigations that were involved there. And we know now that it's about 4 dockets that are involved. And what then the defense wanted to do was to peruse those dockets to get a sense of the investigations that were going on at that particular time when they arrested the accused persons. And yesterday, you'll remember, the court ended early to allow the defense to go through these dockets because Brigadier Gininda did indicate to the court that he had those dockets with him and that the defense were free to peruse them. But of course there was a concern raised about where the investigations are and whether or not this could not potentially jeopardize the investigations that are currently ongoing in these matters. You know that in a criminal matter the defense is only entitled to the docket at a point where they are ready now to go on trial, and that is the phase of disclosure. This premature disclosure may of course jeopardize the investigations, and that is why that particular concern came up yesterday. So it then prompted the judge to make a ruling, an order that says that the defense can only read those dockets in court and not make copies of them. They can then use the rest of the day obviously to take instructions and then continue with cross-examination today. But at the beginning of the proceedings today, it appeared as though there was a dispute between the state and the defense on what exactly the order said, because the defense was of the view that they were entitled to copies of those dockets when in fact the court had said that they can only read the docket. And the court coming in this morning to say that it did indeed say that they can only read the dockets and not make copies. The judge going as far as highlighting a previous occasion, you'll remember, in this very same matter where one of the state witnesses, who is a police officer and an investigator in the Senzo Meyiwa case, brought a confidential document that detailed some of the other criminal cases that involve some of the accused persons. In that particular incident, the judge had ordered that the defense peruse that particular document without showing it to the accused. And you'll remember that in fact that order was broken and the defense did show the accused that document. So in order to mitigate and prevent a similar incident from occurring, the judge then ordered that the defense can only read these documents and take instructions and not show them to the accused. Judge going as far as saying that the defense is not really entitled to these documents. These documents are privileged documents, and he goes on to cite a case that was in the Constitutional Court which involved the state and Shabalala. So he says that they can only peruse these documents, and now they've given the state an opportunity, or rather the defense an opportunity, to go through these documents. The state is telling us that there are about 70 affidavits and they're only allowed to go through the A section of the document. And then, of course, proceedings will resume at 2 o'clock.
very sensitive documents these are, Linda. In fact, I think the judge even intimating as such to say that the lead investigator is of the view that if these documents are allowed to be made copies of, this could jeopardize the state's case. It then leads to another important question, Linda, and that is that whether the defense is going to be able to have enough time, because as one of the lawyers put it, they have to read and analyze these documents. Now, where does that put the defense?
Well, they have enough time at this point, or they've been given time rather, to go through those documents and to analyze them. They've given them about 3 hours. And from what we're getting from the state, these are affidavits that were deposed in these cases. But it's also important to narrow the issues down, because this was dealing with the arrest of the accused persons. So what exactly is the defense going for or pursuing when it comes to the line of questioning that they had yesterday? And that will inform what it is that they get from these dockets. You'll also remember that there's been instances where certain documents are disclosed in the case, and then they come back and just say no, they've got 2 or 3 questions. So the volume of the documents does not necessarily mean that they may need more time to analyze them. It just simply speaks to what exactly it is that they want from these documents. The state had indicated earlier, or the state witnesses had indicated earlier on, that they were still investigating these matters, and the investigations are continuing, and that some of the arrests form part of these cases. If you remember, in the case of accused number 1, Muziga Ukulelwa Sibia, who was arrested on a drug possession, drug dealing, as well as possession of illegal ammunition case, that case was recently concluded. In that particular case, he was recently sentenced to 10 years in prison. This was now during the adjournment after last year. So that case has been concluded, and what, of course, the lead investigator has told the court is that they can still, that information around how far that matter is, or where some of the information is regarding that docket can be brought to court. So it's in line with what exactly the defense wants, and whether or not it will continue pursuing that line of questioning if it finds anything valuable. But you'll also remember the judge yesterday, only touching on the issue around, or in fact this morning touching on the issue around a document that the defense had produced, saying that there were already worries about the handling of these cases, because one of the documents that was produced involving one of the cases in this matter was a document that was only at the disposal of the police. It was not a public document that you and I can easily obtain, and that raised questions around how the defense managed to even obtain that document. The judge even saying, going back to the testimony of Sergeant Mokhane, after he had given the defense the confidential document that was disclosed to the accused against the court order, saying that he was worried at the time about the safety of the witnesses. So there are quite a number of issues to take into account here when it comes to such documents, because there are people that deposed affidavits in these cases, and the investigating team, obviously, as previously indicated, will worry about the safety of the people that deposed the statements, but also about the case itself and where this could lead the case to, given, of course, that the accused may or may not be privy to some of the contents of that particular document. So depending on what the defense comes out with after reading those documents, it will then determine whether or not we proceed this afternoon.
Linda Mnisi, thank you very much for that detailed update.